Hello everyone. Today we will be reviewing the Judiciary Part 2. Government and Political Liberty, 1936 to the present. After 1936, the Supreme Court stopped imposing any serious restrictions on state or federal power to regulate the economy, leaving such matters in the hands of legislatures. From 1937 to 1974, Supreme Court did not overturn a single federal law designed to regulate business, but did overturn 36 congressional enactments that violated personal political liberties. The quote-unquote Nine Old Men. The Supreme Court in 1937. Not long after President Franklin D. Roosevelt tried unsuccessfully to pack it by appointing 6 additional justices who would have supported his New Deal legislation. Justice Owen J. Roberts changed his vote on these matters, and the court ceased to be a barrier to the delegation of power to the bureaucracy. This right here is a picture of the 9 old men. The revival of state sovereignty. For many decades, the Supreme Court allowed Congress to pass almost any law authorized by the Constitution, but since 1992, the court has backed away from this view. There are many examples that show that there are some real limits to the supremacy of the federal government created by the existence and powers of the several states. For example, when Congress passed a bill that forbade anyone from carrying a gun near schools, the court held that carrying guns did not affect interstate commerce, and so the law was invalid. Question time. Who was the first Catholic Supreme Court justice? I'll give you 10 seconds to think about this. All right, let's see the answer. Wow, you were correct. It was Roger B. Taney. All right, on to the next thing. The structure of federal courts. The only federal court the Constitution requires is the Supreme Court, Article 3. All other federal courts and their jurisdictions are creations of Congress, nor does the Constitution indicate how many justices shall be on the Supreme Court. The only Congress created 2 kinds of lower federal courts. Constitutional Court. One exercising the judicial powers found in Article 3 of the Constitution. Judges are given constitutional protection. They may not be fired, nor may their salary be reduced during office. Most important are the 94 district courts, a total of 94 with at least 1 in each state, the District of Columbia and the Commonwealth of Puerto Rico, and the Courts of Appeal, 1 in each of 11 regions, District of Columbia, and 1 federal circuit. Legislative Court, which is set up by Congress for some specialized purpose and staffed with people who has fixed terms of office and can be removed or have their salaries reduced. Some examples are Court of Military Appeals and Territorial Courts. This is a map of the 11 regions. Moving on to selecting judges. Party background makes a big difference in how judges behave. Studies show that Democratic judges are more likely to make liberal decisions and Republican judges are more likely to make conservative decisions. But ideology does not entirely determine behavior. The facts of the case, prior rulings by other courts, and the arguments presented by lawyers can affect the behavior of judges. The tradition of senatorial courtesy gives heavy weight to the preferences of the senators from the state where a federal district judge is to serve. Ordinarily, the Senate will not confirm a district court judge if the senior senator from the state where the district is located objects. The senator can exercise this veto power by means of the blue slip. And so, what I mean by the blue slip is that it's a blue piece of paper on which the senator is asked to record his or her views on the nominee. Negative opinions or failure to return the slip kills the nomination. This means that the president nominates only people recommended to him by that key senator. The party membership of federal judges makes a difference in how they vote. Because different courts of appeals have different combinations of judges, some will be more liberal than others. Differences like this can make some people worry about the litmus test in selecting judges. The litmus test, for those of you who don't know it, is a test of ideological purity. The litmus test has grown in importance. There has been a sharp drop in the percentage of nominees to federal appeals courts who are confirmed. From 1945 until 1970, almost every nominee was confirmed, but in 1995 only about half got through the Senate, and by 2000 it was less than 40%. The litmus test is of greatest importance in selecting Supreme Court justices. Here, there is no tradition of senatorial courtesy. The president takes a keen personal interest in the choices and of late has sought to find nominees who share his philosophy. In the Reagan administration, there were fights in the Senate over the nomination of William Rehnquist to be Chief Justice and Robert Bork to be an Associate Justice, with liberals pitted against conservatives. When President George H.W. Bush nominated David Souter, there were lengthy hearings as liberal senators tried to pin down Souter's views on issues such as abortion. Souter refused to discuss matters on which he might have later to judge. Clarence Thomas, another Bush nominee, also tried to avoid the litmus test by saying he had not formed an opinion on prominent abortion cases. In his case, the litmus test was overshadowed by sensational allegations from a former employee, Anita Hill, that Thomas had sexually harassed her. Of the 145 Supreme Court nominees presented to it, the Senate rejected 29. 5 of these were in the 20th century. Reasons for rejecting a Supreme Court nominee are complex, but have involved such matters as the nominee's alleged hostility to civil rights, questionable personal financial dealings, a poor record as a lower court judge, and Senate opposition to the nominee's political or legal philosophy. Nominations of district court judges are rarely defeated because no nomination is made unless the key senators approve in advance. Question time. Who was the first Jewish Supreme Court justice? I'll give you 10 seconds to think about this. Oh, it went backwards. Okay, hold up. Alright. Wow, it was Louis Brandeis. Great job. Moving on. Okay, the jurisdiction of the federal courts. The U.S. currently has a dual court system, one state and one federal. This complicates the task of describing what kinds of cases federal courts may hear and how cases beginning in the state courts may end up in the Supreme Court. The Constitution lists the kinds of cases over which federal courts have jurisdiction in Article 3 and the 11th Amendment. All other matters are left to the two state courts. Federal courts can hear all cases arising under the Constitution, the laws of the United States, and treaties, federal question cases, and cases involving citizens of different states, which are called diversity cases. Some cases can be heard in either federal or state courts. For example, if citizens of different states want to sue one another and it involves more than $75,000, they can do it in either court. Under the dual sovereignty doctrine, state and federal authorities can prosecute the same person for the same conduct. The Supreme Court has upheld this doctrine on two grounds. First, each level of government has the right to enact laws serving its own purposes. And second, neither level of government wants the other to be able to block prosecution of an accused person who has the sympathy of the authorities at one level. A matter that exclusively within the province of a state court can be appealed to the U.S. Supreme Court under certain circumstances. Thus, federal judges can overturn state rulings even when they had no jurisdiction over the original matter. Some matters are exclusively under the jurisdiction of federal courts. For example, when only a federal criminal law is broken. This goes with the federal district court. If you wish to appeal the decision of a federal regulatory agency, this concerns the Federal Court of Appeals. If you wish to declare bankruptcy. And, last of all, controversy between two state governments, which concerns the Supreme Court. Most federal cases begin in U.S. district courts, are straightforward, and do not lead to new public policy. The Supreme Court can pick the cases it wants to consider. It does this by issuing a writ of certiorari, or certi or certi. I have no idea. The court considers all the petitions it receives to review lower court decisions. If 4 justices agree to hear a case, it is issued and the case is scheduled for a hearing. The court often will grant the court cert when 2 or more federal circuit courts of appeals have decided the same issue in different ways, or the highest court in a state has held a federal or state law to be in violation of the Constitution, or has upheld a state law against the claim that it is in violation of the Constitution. Only 3 to 4% of appeals are granted certiorari. Others are left to lower courts. This results in a diversity of constitutional interpretation. Fun fact: Clarence Earl Gideon studied law books while in prison so that he could write an appeal to the Supreme Court. Wow! His handwritten appeal asked that his conviction be set aside because he had not been provided with attorney. His appeal was granted. Wow, isn't that fun? Another fun fact: Sonia Sotomayor became the 3rd female and 1st Hispanic justice on the Supreme Court. That is absolutely amazing. Okay, well, I guess this is the last slide, everyone. So I just want to say thank you for watching this video. I hope it helped you understand the judiciary a little bit more. Yeah, I hope you all have a great day. And
thank you.
Yeah, that was a B. Do you have anything to say to the class?
Thank you for watching.